Hello everybody, welcome to the 11th video in this series. We are going to be taking a look at the emails that went back and forth between Derek Wright, trial plea counsel for Tounk, and the state, represented primarily by Adrian Love. There are probably other people on the emails. There usually are, but so when I say Adrian Love, I'm using that as a shorthand for the state in general. And I want to show you the timeline of the emails, and I think, hopefully, show you that Derek Wright acted more reasonably than was publicly perceived at the trial. And I'm going to show you a few clips first, just to show you the dates. I have them in a document separately that I'm going to show you, but just for context, I'll show you the clip anyway. So this is the first clip. Just pay attention to the dates where the communications were happening, and I will explain why that's relevant later.
Now, back in November of 2022, did the state seek, do you recall getting an email from me asking whether your client wishes to speak with the state about the case?
I believe November 17th.
Right.
I could be wrong, but I believe that was when I received that email.
And you might have gotten one in November 17th. But did you also give one? I'm going to show you what I have marked and provided to counsel for the defense, but I'm willing to show again as State's Exhibit 450 Yankee, if anyone wants to see it. Sure.
Okay, the defense attorney is going to take a look at the email. So they take like 5 or 10 minutes, so I'm just going to skip ahead. But the main thing, just remember, he said November 17th. The state said it could be the 17th, but there was definitely one on the 30th. So we're just going to say the 30th. That was the date of the first email between the state and Mr. Wright with respect to Antonio's prospective guilty plea or the terms of a plea agreement, just that general topic. And so we jumped ahead a few minutes, and now Attorney Love is just going to run through the emails that are going to be introduced into evidence. There may have been others, but again, just note the dates. Note how much time passes between those first emails and the next.
Are clear for the record exactly which one is which.
Sure.
So State's Exhibit 450 Yankee is the proffer. It's the email dated November 30th, 2022 at 5:44
That's the one that was just mentioned, November 30th.
p.m. From myself to Mr. Wright, and it is the attachment is proffer form Sledge. It says, "Good afternoon, Attorney Wright. It is always good speaking with you." That's the one labeled 450 Yankee. The one labeled 451 Yankee is the email sent from me to Attorney Wright that is labeled Sledge Agreement and dated December 27, 2022.
December 27th, 2022. So the first email was, say, November 30th. That's when the discussions start. And then the state waits. Hold on. Let me show you the time as well.
At 4:57 p.m. It starts
4:57 p.m. So they wait until the night before, at the close of business, the night before the guilty plea hearing, which was set for December 28th, before these emails were exchanged. I'm going to elaborate on that later, but just note they waited 27 days, or over a month, depending on which version you go from, to even start having these discussions. Okay.
And attached to each email is the attachment that was sent at the time the email was sent.
That is how attachments work.
Then 452 Yankee is another email to Attorney Wright that says Sledge Agreement updated, and it is December 27, 2022 at 5:06 p.m. with the
So Wright responds within minutes requesting edits completely on top of things, even though the state waited over a month to begin these discussions.
Attachment Sledge agreement updated. 453 Yankee is the email sent to Mr. Wright from me, dated Wednesday, December 28th, 2022 at 1:45 p.m.
So the next one is the next day. We're now on the day of the plea hearing. The plea hearing was set on the 28th. I mean, it was set for the 28th in advance. So they're now like an hour, about 2 hours before the plea hearing is calendared. And they haven't even worked out the factual acknowledgments yet.
And it is labeled Sledge Agreement Updated 2. $454 Yankee is the email sent from me to Attorney Derek Wright at Wednesday, December 28th, 2022 at 1:46 p.m. Labeled Sledge Agreement Updated 2. And then 455 Yankee is the email from me to Attorney Derek Wright, labeled Sledge Agreement Updated 2, sent Wednesday, December 28th, 2022 at 1:54 p.m. And the body of the email says, use this one at one.
Pay attention to what this email says.
Agreement Updated 2, sent Wednesday, December 28th, 2022 at 1:54 p.m. And the body of the email says, use this one, exclamation point, and attached.
On 12/28/2022 at 1:54 p.m., Adrian Love sent Derek Wright an email, subject line Sledge Agreement Updated 2, with an attachment, Sledge Agreement Updated 2, and in the body it said, use this one with an exclamation point.
Is the agreement or the updated agreement 2. And then 456 Yankee is the email from me to Attorney Derek Wright on Wednesday, December 28th at 2022 at 2:34 p.m. labeled Sledge Agreement Updated 3.
Did you catch that? When she says labeled, what she really means is the subject. Sledge Agreement Updated 3, not 2. It is a new email thread rather than replying to the prior email. But I have this all written out. I'll show you. But again.
Okay. And that's it.
All right. And do you plan?
Okay. So let's go through. I'm going to switch over to. Yeah, here we go. This is my write-up of those emails. There were likely more emails, but these are the ones that were mentioned just then. So the first one from Love to Wright is on. I omitted the 11/17 because the state didn't have that one, but let's just say 11/30. The first one is on November 30th, 2022. There is an attachment. Derek Wright responds. They have a conversation, and then the state waits about 4 weeks, exactly 4 weeks. I don't know how many days that is. There we go. To send an email proposing terms with factual acknowledgments. They wait until the close of business the night before the hearing to begin negotiations on these factual acknowledgments. Now, to be fair, they were selling Thug's stuff during those 4 weeks. They had to sell a couple Lambos. So, they were working on important stuff. Might have been a Rari. I don't know. Fancy cars. And, I just have to ask, if you were really trying to engage in good faith, competent, fair negotiations, are you waiting until 4:57 p.m. the night before the hearing to begin with these factual acknowledgments? And consider that in the context of the last video I did, where I showed that the state didn't do the line-by-line reading of the factual acknowledgments. Does that sound like they're really trying to get, an honest, good faith negotiation on the record? It doesn't, but, you can disagree and be wrong. So, 4:57, close of business. Derek Wright, I believe, calls Love, and then there's another version that same day, the 27th at 5:06. So, Wright's on top of things. I also note this. This didn't come up in the part we watched, but Wright says he believes that there were additional back and forths between these versions, but there were multiple versions on the night of the 27th. Let's see here. 27th, 8:43 p.m. So Wright's working into the evening. He sends changes that he wants, and he testifies that these changes were generally incorporated into the next version, although I believe they're not verbatim. Okay. Next version, 1:46 p.m. on the 28th, which is the day of the plea hearing. It's hours before the plea hearing, and they're still going back and forth. Then we have 4:55 Yankee. These marks are the timestamps of when these were read into the record. So if you want to check my work, you can go to day 125 at 7:06 and see that I'm right. And so 12/28/2022 at 1:54 p.m. the state sends Derek Wright an email with a plea agreement, attached to it, and the body of the email says, "Use this one!" ! Now, what you want to notice here is, first of all, he used the one that said, "Use this one," as one does, because it said, "Use this one." So we use that one. And then 40-ish minutes, 39 minutes later, the state sends Derek Wright another email under a different subject line. They don't use the original subject line. So if Derek Wright had the email chain open and he was refreshing his computer to see if there's more coming in, he wouldn't have seen it because they sent it under a different email thread. And do I think that was malicious? Not really. I just think it's incompetent. That's not how you email when you're staying on a topic. You keep the email within the same thread so that you see it and you have a chain of a single set of emails. And again, Derek Wright's not in his office. He's in the courtroom for this. So he's not going to be in front of his computer the entire time. So here's what happens. It's the 28th. He gets an email at 2 o'clock. Attached to that email is a plea agreement. And in the body of the plea agreement is the text from the state saying, "Use this one." And he used that one. 40 minutes later, the state sends an email under a different thread with an attachment with some shady new terms that weren't agreed to. That's how those got in there. That's how they snuck those terms past Wright. And the guilty plea hearing began at about 4:33 p.m. I don't have any video that proves that or documents that prove that. That's just from my own little knowledge. You're just going to have to take my word on that. I'm sure you could find a way to verify yourself if you wanted to. So this is all happening very last minute. Derek Wright's completely on top of stuff. As you can see here, he's responding within minutes, even though it's at the close of business. And his client's in Wright Street, so he has to find a way to coordinate with his client, who is in Wright Street for this, because of all the lies the state told to keep Antonio in Wright Street. And he's coordinating both with his client in Wright Street and with the state on the spot, and they managed to sneak this email past him because, best case scenario, they don't understand basic email etiquette. So that is the email saga. This is really the issue, this email here. And so I do want to take one step back real quick and point something out. Really more important than all that stuff is really just this passage of time here. because we were going from, at the very least, 11/30/22 to 12/27, oh my goodness, 22. So I believe that's exactly 4 weeks. Please don't blame my lawyer math on this one. The 30th to the 27th is, yeah, that's four full weeks. So they go 4 full weeks with no progress, no negotiations, and then they wait until the close of business, the night before the plea hearing, to engage Wright in conversations, or negotiations rather, with respect to the factual acknowledgments. And I guess I'll show you one little bonus thing that has always driven me crazy. Let me show you here. Switch over to my thing. Here we go. This is the final, not final, the final written version of the plea agreement, although Judge Glanville did reject this version, as we've discussed in several prior videos. It is the state finally agreed, and it's appellate briefing. This is not the correct final version, but it's what the state presented as the final version. Take a second and see if you can see the obvious error. I shouldn't say obvious. It's a kind of a subtle error. The version of the plea agreement that was presented to Antonio to sign was dated December 27th, 2022. In the state's version of events, the state's story is that the factual acknowledgments that were agreed upon on the 28th. But Wright's version, really, if you look at it, go back to the word thing here, is that the terms that he thought were agreed upon were from this version here. Now, he did say that there were other things that were changed, so he didn't think the final version was from the 27th, to be fair. But he did think that more or less the final version of factual acknowledgments was from the 27th. And again, if you look at the face of the document, it says the 27th. So, it's not insane to think that if the document says the 27th, it's going to reflect terms from the 27th. Because if you add terms on the 28th, it should say the 28th. Because that's how dates work. That's just fundamentally why you date a document. If this was in corporate America and you showed a judge, hey, we were negotiating this agreement and there's a dispute as to the terms, and the document is dated the 27th, but you're trying to sneak in terms that were negotiated on the 28th, he would laugh at you. If it was federal court, federal judges have a button. They can push it on their little pulpit thingies, and it'll actually drop you into a pit of lava. It's a true story. If you tried to make that argument, they'd push that button. You'd be gone. Rip. You can't say the terms are, if you have a dispute and you're saying the terms are on the 28th and the document's on the 27th, you're out of luck. Especially if you wait weeks, almost a full month to begin negotiations when you have a drop dead date the next day. It's due the 28th and you start negotiating the night of the 27th and there's a discrepancy. No. And there's another rule. I don't know if this applies in criminal law, but in civil law, if there's an ambiguity in the form, it is interpreted against the party that drafted the form, which in this case would be the state. yet another reason why this should have gone in favor of Derek Wright and in favor of Antonio. And, you know, I'm not saying that Derek Wright made no mistakes, that he didn't miss anything. He did. You know, he could have done stuff better, and he will. I've never spoken to Mr. Wright, but I'm sure he would acknowledge that. But all of this is born out of the state's incompetence and laziness, inattention to detail, perfidy, which is a word I learned recently. You know, again, I'm not saying he bears no blame whatsoever, but this is like a 98%, 2% situation. Derek Wright behaved like a lawyer does, and he missed some stuff. If the state had acted with the same diligence and competence that Derek Wright had, there wouldn't have been a problem. You are supposed to be able to rely upon the representations made by opposing counsel. You are supposed to be able to expect a certain degree of diligence and competence, and that just wasn't there. And to the extent that Derek Wright failed, it was because he didn't catch the incompetence of the state, or if you want to say worse than incompetence, I'm not going to disagree with you, but duplicity, whatever, he didn't catch their failures. His failure was that he didn't do his job and their job. He did his job, but they didn't. That's what this is. And, you know, could he have done better? Sure. But he shouldn't have had to, is my point. So thanks for watching. And yeah. Whoa, that is a longer video than I intended. I must have been ranting in there. I'm going to enjoy watching this later. But yeah, thanks for listening. And yeah, I should have another one soon. I'm not sure about the next topic yet. But when you see the video, I'm sure you'll know. Thanks for watching, everybody.